The marble echoes of the Supreme Court fell silent as Justice Marcus Langley's gavel struck with finality. Before him stood two visions of American democracy, one embodied by the tech billionaire whose platform reaches millions, the other by a congresswoman claiming to defend constitutional rights from corporate overreach. Elon Musk, the mercurial lord of Platform X, faced Congresswoman Jasmine Crockett in a constitutional showdown that would determine whether digital speech truly remained free or had become another commodity to be manipulated by those with sufficient resources. The air crackled with tension as America's most fundamental values were placed on the judicial scale. Who truly defends your constitutional rights? Elected officials or tech visionaries operating outside traditional governance? Stay with us as we dissect this landmark confrontation that may reshape your digital existence. Subscribe now to ensure you don't miss our analysis of the most consequential battles in America's courts. Justice Marcus Langley fixed both parties with an unflinching gaze as he outlined the case that had captured national attention. Congresswoman Jasmine Crockett is suing Elon Musk and the Department of Government Efficiency for alleged violations of the First Amendment, using biased algorithms on X to control content, suppress dissenting voices, and abuse executive power by illegally firing thousands of federal employees. Crockett rose from her chair with practiced authority, her voice carrying throughout the chamber with sharp precision. Mr. Musk manipulates democracy through algorithmic control while portraying himself as freedom's champion. Her words hung in the air, heavy with accusation. His platform systematically suppresses views critical of his government partnerships while amplifying those that serve his financial interests. Somewhere among the gallery, a reporter's pen scratched frantically across paper. The American public would consume this confrontation like entertainment, even as it determined the boundaries of their digital lives. Musk, for his part, maintained the inscrutable half-smile that had adorned countless magazine covers. His stillness provided stark contrast to Crockett's animated delivery, a calculated performance of the composed executive, unfazed by government overreach. Do you believe tech platforms should operate with the same constitutional constraints as government entities? Share your perspective in the comments below. Crockett's opening gambit emerged with clinical precision. She presented findings from civil rights organizations, suggesting X's algorithm favored content supporting the Department of Government Efficiency, known colloquially as DOGE, while restricting posts critical of its operations. 20% of public issue posts addressing DOGE activities face restriction, she asserted, though no specific data source materialized to support this claim. On the matter of federal employees, Crockett's accusations sharpened. Mr. Musk, through his influence over DOGE, orchestrated the termination of 12,000 federal employees without congressional approval, a flagrant abuse of executive authority. Her conclusion arrived with theatrical flourish. Musk operates not as a businessman, but as a technological dictator unfettered by constitutional constraints. To substantiate her claims, Crockett called former FCC employee Sarah Whitaker to the stand. Whitaker testified with visible discomfort about receiving a call from Musk himself, allegedly demanding looser oversight of Platform X and implying DOGE intervention should she fail to comply. Langley's response sliced through the chamber's tension. "Do you have specific evidence of this threat, Ms. Whitaker?" The witness's hesitation spoke volumes. "Only my personal impression, Your Honor." The justice's pen scratched a note, his tone glacial. "Impressions are not evidence, Ms. Whitaker. Do you possess documentation or recordings of this interaction?" Whitaker's negative response left Crockett momentarily adrift, her confident demeanor briefly fracturing before she reassembled her professional mask. If you're finding this analysis of constitutional principles valuable, tap that like button to help others discover it too. Langley turned his penetrating gaze toward Crockett. "Congresswoman, you rely on this testimony to claim Mr. Musk coerced a federal agency without presenting evidence. What jurisprudential value does such testimony hold?" Musk seized this momentum with the precision of a chess grandmaster. "Congresswoman Crockett transforms subjective impressions into legal facts," he observed, his voice carrying the practiced nonchalance of someone accustomed to boardroom domination. "If such a call occurred, surely call logs exist." Crockett's promise to provide them later earned Langley's swift rebuke. "The court requires evidence now, Congresswoman." The confrontation's rhythm shifted when Crockett presented an internal DOGE document purporting to demonstrate Musk's direct involvement in federal terminations. Yet Langley's methodical dissection exposed its limitations. This document outlines restructuring goals, Congresswoman, not specific decisions by Mr. Musk. Musk countered with characteristic precision, noting the document represented, quote, a general Doge plan approved by congressional appropriations. When Crockett insisted on his control over Doge operations, Langley's intervention arrived with icy finality. Accusations require proof, Congresswoman, not emotional appeals. The technology world increasingly shapes our constitutional reality. Share this analysis with friends concerned about the intersection of digital rights and governmental authority. Musk's formal response revealed the strategic mind that had built multiple corporate empires. Congresswoman Crockett substitutes emotional rhetoric for factual evidence. Doge operates under presidential authority, and X, as a private platform, retains legal right to content management decisions. His concluding challenge hung in the chamber like frost. If you're making accusations of constitutional violations, bring actual evidence. The room's subtle reaction, a collective intake of breath, the shifting of reporters in their seats, suggested Crockett's position had weakened considerably. Her attempt to extract more specific testimony from Whitaker regarding Doge pressure only invited Musk's clinical deconstruction. Which meetings? What dates? Who attended? Without specificity, it's merely unsubstantiated assertion. Langley concurred. The court cannot accept vague testimony, Congresswoman. Crockett's pivot to a research report claiming X amplified misinformation to public detriment failed to salvage her position. Langley's interruption carried unmistakable finality. This report does not establish constitutional violations, Congresswoman. Your focus must remain on specific evidence. This intervention left Crockett visibly diminished. Her earlier confidence evaporated under judicial scrutiny. Musk, detecting blood in the water, requested permission to supplement the record with legal precedent. Citing Citizens United and Reed v. Town of Gilbert, he methodically established X's content management rights. Congresswoman Crockett attempts to criminalize free speech expression, he observed with delicate irony. But the Constitution provides explicit protection. What concerns you more? Government regulation of online speech or corporate control of digital conversation? Your perspective matters. Comment below with your thoughts. Crockett's final emotional appeal, the story of a single mother rendered jobless by Doge decisions, met Musk's implacable logic. Emotional narratives cannot supersede legal frameworks. Doge's decisions followed congressionally approved budgetary guidelines. The gallery fell silent save for the scratch of pens and whir of camera shutters. Langley concluded the session with unmistakable emphasis. I expect substantially more concrete evidence at our next meeting, Congresswoman. The first round of this constitutional battle had concluded with Crockett strategically disadvantaged, her emotional appeals proving ineffective against Musk's evidence-driven approach. When proceedings resumed, Musk approached the podium with the calculated confidence that had become his public signature. Congresswoman Crockett has presented an emotionally compelling narrative, he acknowledged, but constitutional jurisprudence operates on evidence rather than speculation. With methodical precision, he cited the landmark 1952 Youngstown Sheet and Tube Company v. Sawyer ruling, analyzing executive power's 3 tiers and positioning Doge, authorized by presidential directive and congressionally funded, at the highest constitutional level. His evidence emerged with devastating specificity. He highlighted a federal budget line item explicitly approving administrative restructuring. What Congresswoman Crockett labels abuse, he noted with subtle emphasis, is simply efficient execution of constitutionally mandated processes. Langley's attentive note-taking suggested judicial engagement with Musk's constitutional framework. Pivoting to Platform X, Musk dismantled content control accusations by citing Citizens United v. FEC to establish private entities' First Amendment rights. He presented 16 detailed responses to FCC oversight demands, methodically demonstrating their lack of legal foundation. Crockett's interruption, claiming Musk distorted precedent to conceal manipulation, lacked her earlier confidence. When Langley asked her to cite specific laws Doge had violated, her inability to produce immediate references further weakened her position. The constitutional principles at stake affect your digital rights every day. Subscribe to stay informed about these crucial legal battles shaping America's future. Musk projected a comparative chart showing FCC regulatory overreach against established precedents like Verizon versus FCC, exposing what he characterized as arbitrary demands targeting Platform X. Congresswoman Crockett positions me as freedom's adversary, he observed with calculated precision, while actual threats to expression originate from regulatory overreach. The courtroom's subtle reactions, reporters nodding heads, spectators' whispered exchanges, suggested the narrative had shifted decisively. When Langley questioned Musk about algorithmic suppression allegations, Musk presented internal X analytics showing a 30% increase in content volume since his management changes, including substantial DOJ criticism. If I were implementing suppression as alleged, he asked with rhetorical flourish, why would opposing perspectives flourish on the platform? Crockett's attempt to introduce an NGO study about social division earned Langley's swift dismissal. Its relevance to First Amendment claims remains unclear, Congresswoman. Musk continued his methodical dismantling of Crockett's case, briefly recounting X's founding principles of speech protection. When Langley inquired about DOJ's termination practices, Musk produced budget documentation explicitly authorizing restructuring initiatives. His closing statement arrived with understated force. Congresswoman Crockett constructs a narrative casting me as constitutional antagonist, but both DOJ and X operate as defenders of foundational principles. The decisive moment arrived when Musk introduced previously undisclosed evidence, a collection of FOIA-obtained internal FCC emails revealing what he characterized as a coordinated effort to restrict Platform X. One email, prominently displayed, contained damning language. X must be controlled before it shapes public opinion beyond our reach. If this analysis helps clarify complex constitutional issues, give it a thumbs up and share it with others navigating today's political landscape. Musk parsed each communication with surgical precision, exposing what he described as censorship disguised as regulation, a textbook First Amendment violation. Crockett's objection, that these emails don't prove innocence, appeared increasingly desperate against Musk's methodical presentation. Langley's intervention. Congressman Crockett, Mr. Musk has presented specific evidence. Do you possess documentation refuting these communications? Only highlighted her evidential deficiency. The coup de grace arrived in the form of a legally obtained recording from a DOJ FCC meeting, wherein an FCC official acknowledged that regulations targeting X stemmed from political pressure rather than legal necessity. The courtroom's reaction, reporters frantically documenting, Crockett's team exchanging alarmed glances, signaled a decisive shift in the case's momentum. To solidify his position, Musk cited three additional precedents: Chevron USA Inc. versus NRDC, NetChoice versus Paxton, and Texas versus Johnson. Each citation constructed another layer of his constitutional defense, establishing both the FCC's limited authority and X's First Amendment protections. Crockett, attempting recovery, called data analyst Dr. Emily Carter to testify that 25% of DOJ-critical posts faced restriction, suggesting deliberate censorship. Yet Musk countered with audited internal data demonstrating uniform content moderation, regardless of political perspective. More devastatingly, he projected analytics showing DOJ-critical content actually enjoyed 35% higher visibility due to engagement algorithms. When Carter admitted her analysis lacked complete data context, the courtroom's subdued reaction reflected Crockett's diminishing position. The media plays a crucial role in how we understand these constitutional battles. Hit subscribe now for analysis that goes beyond sensational headlines. As proceedings concluded, Langley fixed Crockett with an uncompromising assessment. Mr. Musk has presented substantial evidence. The court expects a compelling response if you have remaining arguments. Crockett's final attempt, emotionally recounting a family affected by DOJ restructuring, encountered Langley's constitutional reality check. Emotional appeals cannot replace legal evidence, Congresswoman. Musk delivered his conclusion with characteristic precision, presenting sworn affidavits confirming all DOJ actions aligned with congressional appropriations and established legal process. Media coverage immediately framed the confrontation as a decisive victory for Musk's evidence-based approach over Crockett's emotional appeals. Headlines proclaimed his legal acumen while questioning Crockett's preparedness for constitutional litigation of this magnitude. Tech companies from various sectors expressed support for Musk's position, challenging regulatory transparency and positioning him as a defender of digital speech rights. Meanwhile, Crockett's previously vocal allies maintained conspicuous silence, perhaps recognizing the evidential gulf between the opposing cases. Legal analysts began dissecting Musk's strategic approach, noting his preparation depth and precision in applying constitutional precedent. A Harvard law professor observed, "This case demonstrates the critical importance of evidence-based argumentation in constitutional litigation." The confrontation between Congresswoman Crockett and Elon Musk transcends individual personalities to illuminate America's fundamental tensions between governmental authority and private enterprise, between regulatory oversight and innovation freedom, between different conceptions of speech protection in digital contexts. This case reflects broader societal questions facing every American. Who should determine acceptable speech in digital spaces? What limits should constrain executive authority in government modernization? How do we balance innovation with accountability? The constitutional principles at stake will shape not just platform policies, but the very nature of American discourse. Whether you align with Musk's evidence-driven defense of private platform rights or Crockett's concerns about concentrated tech power, these questions demand engagement from every citizen who values constitutional governance. America's founders could never have envisioned platforms connecting billions or algorithms determining information access. Yet their constitutional framework remains our guide through these unprecedented questions. The resolution of cases like this will determine whether that framework maintains its relevance in our digital age. The clash between Crockett and Musk represents more than a Supreme Court case. It symbolizes America's ongoing struggle to apply timeless principles to revolutionary technologies. As we navigate these waters, evidence-based reasoning, rather than emotional appeals, must guide our constitutional journey. Thank you for joining our analysis of this landmark confrontation. If you found value in this deeper examination of constitutional principles at work, please subscribe to our channel for continued coverage of the cases shaping America's legal landscape. Remember to share your thoughts in the comments. Your perspective enriches our collective understanding of these complex issues. This is Karoline Now, bringing you the constitutional battles that matter. Until next time, stay informed and engaged with the principles that define American democracy.